Everybody. Welcome to the IRI's, the RTM Lunch and Learn session with Paul Germeraad, who I'm very happy to welcome today to talk about the way that intellectual property strategies need to shift as a result of, especially for physical product companies, as digital technologies sort of affect everything. I found this article really interesting and very practical in my own work. So I'm hoping that everybody gets a chance to read the article, but also to probe Paul with more questions. This is a point of view article. It's based on Paul's, sort of career dealing with intellectual property issues. He worked with large companies early in his career with Raychem, Charles River, and Avery Dennison, and he's also consulted. He's also a past president of IRI, and he won Holland Awards twice. So he's a good thinker as well. I'd like to just say for Q&A, we'll let Paul get through his material. That'll probably take half an hour, and then we'll have half an hour or 25 minutes for your questions. I think it's helpful if you post your questions as they occur to you in the chat, and then I will pull questions from the chat at the end to make sure we cover everything. I may call on you to elaborate your question, so please feel free to do that. And with that, I'd like to welcome Paul and ask him to go ahead and begin his presentation. Thank you for joining us, Paul.
Thank you, Jim. Thank you for the kind introduction. So as Jim said, we're going to talk today about traditional product companies and their need to shift their patent strategy for digital products. And this is, as Jim said, a point of view. It came about as I've been working in networks of companies that worry about integrating their R&D and intellectual property strategies. And what really came about from my work here in Silicon Valley is the digital products, the way in which you go about creating a strong position for your company and is very different than what I was brought up with, because my career's foundation was in traditional product companies. So because of that shift, wanted to share it, and that's what I'll do today. Now, to do that, I'm going to go through the material. The way I'm going to approach it is, first, I want to give a little bit of background about why would you need a different strategy. Then there's different environments. I want to talk about that. Then I want to talk about, well, if there's different environments, what are the distinctions between different kinds of IP strategies? The traditional one, the jargon for it is freedom to operate. The digital strategy is often called freedom to action. And then I want to explore those differences from three different kinds of viewpoints. What does this look like to an executive? What does it look like to an R&D team, patent committees embedded in R&D organizations? And then what does it look like from the licensing and litigation standpoint? And finally, just a summary about what actions a company might take as it moves from the traditional product and it adds a web interface or an ability for Alexa to control it or something like that. How do you want to protect that type of a product addition? So to get started then, I always like to start with the end in mind. Kind of got that from Stephen Covey. And the way I look at it, the vision and mission of R&D organization is really to provide a company with a stream of new products. They're to possess a sustainable, advantaged, competitive position on introduction, and that they should be sufficient to meet the company's short and long-term sales and profit objectives. And that's sort of where my feet were to that fire when I was leading R&D organizations. Now, for the purpose of this discussion, I want to focus on that second bullet point, to possess a sustainable, advantaged, competitive position. Now, when I started in R&D, I was taught to create an advantaged competitive position. I was getting paid to do research to create something new, Something new had to do better. It had to have better performance in the market than what was out there already. It would have to have higher quality. In some cases, I was given a challenge to pull cost out of a product. That I was trained to do. What I had to learn how to do was make it sustainable, and that required an intellectual property strategy. That would be patents, copyrights, trade secrets, trademarks. So that's where the sustainable comes in and why we need to talk about it today. Okay, let's talk a little bit about the two different kinds of environments that when I ran and I just so you know, I ran R&D organizations on both sides of this fence, and I'm presenting it to you today sort of matter of factly. Believe me, when I was doing this, it was a lot of art and not as much guidance as we now know in the world at this point in time. So for physical products, the environment that I would find myself in there is that the time from R&D, thinking of an idea to the time you commercialized it, it was quarters or years. And the patent applications that we would file before commercialization, they would often be public before any competitor could introduce a new product. That was just the nature of the time frame. And that when we look to see, gee, are we going to be able to create a unique position in this field? Is there anybody else's art we need to respect? We could go to the library at the time or online later on and search for prior art. And what we found is that there wouldn't be that many patents. There would be maybe 2, 3, 5, maybe in a worst case 50 to 100, but it was manageable to go through it and behave responsibly. The other environmental factor in this particular product area is that the courts order competitors to stop making and selling the offending product. As I was taught, a patent prohibited somebody from using, or selling, manufacturing kind of thing. Well, and that's what they did. In fact, I was party to getting other companies to stop making the chemicals that I had come up with, to stop making the unique polymers, to stop practicing the processes that I used. And they had to shut down factories, and they were ordered to do so, and they were responsible, and they did it. Now, I contrast to later in my career here in Silicon Valley, it's quite a bit different. The products and services rapidly evolve. There's constant churn. If you think about your phones, the computers that you're probably watching on, how often do you get an update? I mean, it is just constantly new and improved products and services. And what this means is the speed of these introductions outpaces the time required to obtain and enforce patents. They're just overrunning it. So things are in the marketplace before anybody even knows that it might have contained a feature that had protection. The other thing is that there's hundreds to thousands of patents that people have to look at if you decided to look at it at all. In fact, there were some experiments run here in the valley where they had product teams working on a new product, and they had in essence an IP team at the same time trying to research, gee, is there any prior art in this area? And the IT team had to be almost, or the intellectual property, IP team had to be almost, if not bigger than the product team, just to keep up. And even then they really ended up throwing up their hands. They couldn't give good guidance to the people actually doing the development work. The other thing about this type of digital environment is that the courts, because of this churn and this mishmash and everybody's patented stuff that other people have sold, what they decided, right or wrong, it's just the environment that we live in. The courts, instead of ordering them to stop, giving an injunction, what they do is they award damages and patent royalty fees, and they allow the offending company to stay in business. And the logic is as well, if we award a running royalty damage, so to speak, on the offending company, instead of putting them out of business by forcing them to just stop making it with an injunction, we just force them to have a decreased competitive position, because they have to pay a royalty to you based on and so they have to basically eat into their own profits. And potentially in the worst case scenario, if it's not done right, they can own more in royalties than they make in profits. And that way they go out of business just because they choose to, because it's not money making. So those are the two kinds of environments. And if you put that in your head, you'd say, okay, so what kind of an IP strategy would work best in each of those two different environments? So the first one I said was called a freedom to operate strategy. That's just jargon that the lawyers use, if you will. Here you want to patent a breakthrough work early. You want broad, and I'm going to use the word litigation quality claims. What that means is that when you're getting them, you don't have just the patent attorney draft them. You actually take them to a litigating attorney and have that person see, is that claim written sufficient that I can get a court injunction? That's a much higher standard, but that's the way you really want to be able to enforce patents for which you're going to want to obtain an injunction. And later on, you want your R&D teams to build out patent fences with their continuing next generation work. Remember, this is just much slower pace. And in the end, when you look at a field of art, you typically end up with 1 to a dozen patents in an area. I mean, when I was doing synthetic work in the pharmaceutical area, you'd end up with a couple of them. In the polymer area, there maybe be, a half dozen. When I was in the process area, you might end up with a dozen or two. Switching over to the digital products area, when you think about the environment that I just described, what would you want to have your intellectual property strategy to be? And here is the jargon it's called freedom of action rather than freedom to operate. Again, just jargon. But the strategy comes down, you want to patent early, you want to patent often. Here you want reasonable claims. I mean, you just don't want junk turned into the patent office. But on the other hand, you don't need a litigating attorney to overlook it. You just want a patent attorney. If they can get it through the patent office, it's good. Because later on, it's just the patent count that's going to go into the royalty calculation, not the quality of the claim. So you want to build a portfolio now it's of equal size and bargaining power to the largest competitors. So it's about building a portfolio that has the relative size and mass, where if you look at the strategy up above for the traditional one, you want that litigation quality claim. So the second digital strategy, you typically end up with a dozen to hundreds of patents. Okay, so I gave those high-level strategic differences. What does this look like from a couple of different viewpoints? And again, this is a pretty high-level summaries that I'm giving you, but hopefully it will be good to start a discussion. So from an executive standpoint, if you think about how traditional products were viewed and you talk to an executive, they can usually tell you, well, I've got freedom to operate. They usually talk about, I have the ability to exclude. And if you look at the bottom row there, I often heard a CEO say, I own and control this market. And so it's about business exclusivity, okay? In the digital product environment, think of the Apple and Samsung patent wars. And what everybody learned from that is that, well, no, it's not about exclusivity. It's about you have freedom to action. You have the freedom to participate in the market. You can keep your product in the market if you have a portfolio of a sufficient size. And there, what you really want is a portfolio that can assure mutually assured destruction so that hopefully no one sues you. And if not that, you at least want, if you get into negotiations in the royalty phase of or damages phase of a lawsuit, you want them, when they run the patent counts, you come out about the same amount as the other person. And as part of the suit, you've countersued them and they've countersued you. So it's just a negotiation in the end. And it's basically who's got the most patents that are relevant. And the courts, not literally, but almost, just count them up and look at the ratio, and that's how they split out the profits. And believe me, it's not that simple. But if I look at the output, that's the easiest way that I can think of how I would build a strategy. Okay. Let's take that to the R&D standpoint. If the executives got that in their mind, they're okay. But now from an R&D standpoint, well, what's happened? I already talked a little bit about the environment. What does that mean? Traditionally, when I would start a project, the first thing I'd do is go to the library, jump on my computer and run a patent search, and I'd get a whole bunch of art back. By a whole bunch, I mean maybe a half dozen, couple dozen patents, and I'd go through them and I'd make sure, okay, my idea is different. Nobody here has ever put an amine group on a fluorosilicone polymer before. Looks like I'm okay, so I can go do it. I mean, it was that kind of a search, that kind of methodology. Gee, I'm going to put a stainless steel spring of this particular configuration on this opener so that it's going to work in a rotary rather than a reciprocal fashion. I can run that search. I found out that maybe somebody's done it in automobiles, but nobody's ever thought to do it in vacuum cleaners yet. And it's, you know, I'm probably good to go. That's what an R&D team faces. You can do it. When you find something, it could be make or break. So you really don't want to start a project unless you know you're clear, and you really want to make sure as a product team that as you go through these months and quarters of research that you're always checking, are you still clean? Digital software is completely different. It is, you're just doing sprints, you're doing lots of work, there's lots of churn. As I said, there's just hundreds to thousands of patents out there. There's really no good way to keep up with it. And what people have decided is best practices, you just don't do it. You just have the team run with it. And what you do is you sit there and you look at your competitors, look at how big their portfolio is in the area you're entering, and you target your team to create a patent portfolio the same size. And where that's not practical because of the size of the team, and you saw this with Google and Facebook when they were first started, what you have to do is you have to allocate money to buy your way you buy other people's portfolios. And later on, with the advent of defensive aggregation, you buy your way into a patent pool to protect yourself. So that's how it plays out from an R&D standpoint. And here the patents rarely define the product development team's efforts. They're just free to go, free to invent, free to commercialize. Now, third viewpoint, licensing and litigation. I've alluded to licensing a little bit already. In a physical product environment, usually you expect the R&D team to do all the work themselves. It's a new area, they can go do it. Every now and then they run across, they need something specific that somebody has a product on. My case, we were, developing a particular kind of label. We needed a specific conductive ink. It had to have a specific conductivity. It turns out it was already patented. We went and took a license for that very specific niche product for our need. But when you license stuff in, it was just for very specific product objectives. And when we were done, we patented the heck out of our product with some really good litigation quality claims, and we were able to get injunctions against competitors. That's very different from what is in the software thing. As we said, it's about mutually assured harm capability. We develop products, patent a lot ourselves. And when it came to working with the licensing groups, we asked them to investigate patent aggregation pools and look at the costs associated with, joining those types of entities for the protection purposes, and also a little bit for assertion. And then at the last thing, litigation outcome. I think I've belabored this point enough. Exclusivity versus just paying a royalty penalty. In closing then, and so we can start our discussion, the modifications that a traditional company is going to want to take. You're going to want to thinking of these two environments, the two different kinds of strategies that's needed, and the fact that since you're taking a traditional product and bolting on a digital component to it, you're going to want to make sure both are integrated. So kind of straightforward in a way, easy to say, a little bit more difficult to do. You want to certainly maintain your existing patent creation and management processes for your additional product. and you want to build alongside, not instead of, the ability to create a digital portfolio. You're going to need the employees to do that, and they're different. And it's specifically different when it comes to your patent committees. As you can see, there's a different approach, and the toughest thing for a patent committee to do on the digital side is answer the question, how big a portfolio do you need? And believe me, there's been big name companies here in Silicon Valley that have been for the last 10 years, and still today, when I go to private conferences with them, they are still grappling with the thing, how big should portfolio do I have to have? And the reason that's critical is, remember, if you own the patent, you've got to pay to maintain it. And if you're trying to maintain hundreds to thousands of patents, or in big companies, tens of thousands to hundreds of thousands of patents, that's a lot of money in maintenance fees. So the question, how big does it need to be, becomes very critical. And it takes some real skill to answer that question. Different skill than if you're in a traditional company. Likewise, the other watch out that I would say is for patent counsel. Those that are experienced in maintaining what I call traditional product patents, that's a real skill, and it's different than the skill in obtaining digital patents. It takes a different mindset and a different point of view. And I have not yet, and this is just a personal statement, I've not yet run across a single individual that I consider an expert in both areas. So that means you need to either be using a firm that has both a team that's focused on both those kinds of strategies, or for most companies, it means you're using different law firms to prosecute your patents. And lastly, and I can't emphasize this enough, you need to make sure you've educated your senior management on these differences, so they're not surprised why all of a sudden they're getting a bill to join a patent pool, or why they're seeing that you've got bills from two different law firms, or, I mean, you don't want them to be surprised, and you want them to understand that when they decide to talk aggressively in any of their own peer meetings, that they know that they can talk about owning a market in a traditional sense, but that's a bad idea and a bad word choice when it comes to the digital side of their business. Well, with that little comment, I think what I'm going to do now is I'm going to close my presentation and take questions. As Jim said, the paper was published in RTM. Please see it for more details. And the other thing is that I've got a website up that's got a lot of insights on best practices in innovation, best practices in intellectual property management. Jim, I'm going to let you take the floor.
Good. Thank you very much. It's very thought-provoking, I think, for those who are trying to manage in this transitioning world. And we have a couple of questions already, and then please, others, feel free. I have some I would add as well. So Bill Miller asks, what strategy, Bill, you might want to clarify, but what patent strategy is required for physical products that have digital components? And I think that's a bit of what you're trying to help address, but can you, Bill, can you elaborate on that?
Sure. Can you hear me?
Yes. Yes.
Yeah, so as an example, let's go back in time and history and take the automotive industry. Years ago, they started putting digital controls on their engines. And so that became a big feature. I mean, a really key selling point, because you got better response and fuel economy and so forth, right? So when you have products like that are, for years were predominantly just physical with no digital component at all, and then you start introducing digital components, what kind of patent strategy do you use?
Yeah, so there I think the answer is in my mind, I behave as a schizophrenic. I think about how can I build out a portfolio to protect the physical side, and then to your point, that would be the basic thing. The pistons are made out of a new alloy that has this or that feature. But then on your point on the engine control side, my little engine computer, there I have to take more of the digital strategy and think about, well, I want to know how big a portfolio, let's just say I'm GM, how big a portfolio do the other major automotive companies have in this area? And I'm kind of matching that, because I really don't need to reverse engineer their software, but I suspect that they and I are probably using very similar algorithms. When I start to put my patents out and I look at their patents, I see that they're awfully close to one another. They have a nuance, I have a nuance, but when I look at it, I look at it very carefully, I see that, oops, I kind of might be infringing some of their claims, and I suspect they're doing the same to me. There, from a strategic standpoint, what I would want to do is on the engine control size, I'd be thinking about, is my portfolio about the same size, mass, quality as the other competitors. Whereas on the engine piston side, so to speak, I'd be thinking about, gee, have I got a bulletproof, litigation quality claim about the composition matter of the piston material? I don't know if that helps you, Bill.
Can I ask one more question?
Sure.
So my question really is, to go back to the automotive thing with digital controls on engines, do you write the patent for the vehicle saying you can't put a digital engine control on the car, and that becomes a blocking patent for physical products that have digital controls?
Originally, the answer was yes, but that world in almost all fields is long since passed.
That's strange. Is that because of the difficulty of innovation or the courts?
No, just because for most fields, people have already almost everything that we use is people have already started doing digital products. So the answer is, if you were truly the first person to put a digital control on something that I haven't thought about in a unique way, you can certainly get that patent. But just putting a digital control on an object is I don't want to get into patent prosecution here, but I will wager that just saying that I'm going to put a digital control on my coffee cup isn't going to be patentable anymore, because people have put digital controls on so many things, it no longer meets the requirement of being a novel invention. So it would have to be something unique about the digital control that I did for my coffee cup. I just don't think it's possible to get claims anymore on just adding digital to something. That's an opinion.
No, I agree. It has to be unique, but I can think of many ways to make it unique. Thanks.
Yeah.
I think that's that's part of the trick, right? I think, Paul, you're sort of saying, yeah, do whatever you can to get as broad a claim and as strong a claim as you can on the physical product, but just recognize that that may not be the best business strategy in this digital world because of the way these patents are adjudicated.
Exactly. And when it comes down to the digital side, the courts are going to lean to doing a rather than giving you the injunction, they're going to lean to giving you the fair and reasonable royalty. And what's going to happen is if your competitor that you're suing out there has got a similar, also has a digital control of some kind on the object that you're talking about, it's gonna kind of get down to this. It's probably going to get closer to my patent count example than a claim quality example that you would find in a traditional area.
Well, with that, I'm going to go to the next question. It's Dan is asking about, detectability of a patent, of infringement of a patent as a criteria for your filing strategy, and where does that fit in?
From a filing strategy, what I would say is the detectability for me typically involves what kind of property protection I want to use: patents, copyrights, trademarks, trade secrets. You want an integrated strategy there. often detectability has to do with whether you wish to have a patent or a trade secret. And so that's when somebody talks to me about detectability, that's kind of where my mind wanders off to. With respect to detectability here, on the software side, they're often protected by copyrights, but then that's the literal, code that's written. And if you've been honorable, you probably hopefully won't have had you won't have had copyright infringement. But if you've got it from third parties, you have to watch that a little bit. But with respect to the distinction between the two strategies here, if you're considering patents, detectability of patents in the physical space and detectability of patents in the space of a digital product, I would say that doesn't really alter either strategy by too much. I've always think it's wise to assume that people are going to be able to detect what you've done with if they want to, they can. And anytime I've wanted to reverse engineer something that I wanted to, I've been able to. You can say, well, gee, some of the, some things are much harder to detect than others, both because you want to do it honorably. But if you're running products and you're going to the trouble to get patents, my personal behavior is I just always assume they're detectable.
And Paul, when we're sort of talking about this digital physical, or some people call it phygital products, where they're at that interface, they're smart connected products, all those kinds of things. Does you still may have a device that has really unique features or materials or whatever. Do the patents, the litigators or the judges, do they treat those the same even if the patent isn't about the digital? You say you have a competitor who infringed on a digital patent of yours, or you infringed on one of theirs, and you get into litigation. Do they take the stronger composition of matter patents or whatever and throw them in with the digital patents and do the calculation there, or
no, you're
roll that off?
Yeah, no, you remember what when you go to court, you're actually suing on the basis of patents. You're claiming that somebody is infringing patents, and you have to name off the ones that are infringing. So if it's party to a suit that the patents are named, and usually you have in the digital area, the person doing the initiation of the suit names their patents they think are infringing, and it's very typical to have a countersuit where the other person says, okay, but you're infringing all these of mine. In a product space, that's not often the case. Usually there it's here's my composition of matter, you're infringing it, we've run the studies, you happen to have this composition of matter. So they are kept distinct in the court, and the courts tend not to they tend not to get lump too many things in the same area. Although I will point out that when you go to the Apple and the Samsung case, they in the end broaden those suits to the point where they were suing over everything. I don't know if you remember, but they were suing over how round the corners were. They were worrying about the plug interfaces. They were worrying about the display thing. I mean, they had the kitchen sink in that lawsuit, and that's why it ended up taking as long as it did, cost as much money as it did, and why in the end Apple and Samsung, both CEOs said they would never do that again. It's if you throw the kitchen sink in your lawsuit, you're likely to make the lawyers rich and nobody else.
Okay. We have a question from Sun Hee. If you receive a cease and desist letter, what do you do with physical products? Do you re-examine it, negotiate directly, join a patent pool? What's the most effective defense?
So I don't have any good general advice there, because when we're talking about the range of digital stuff,
Yeah.
it's all over the map. So there are certainly some areas. If you're worried about the communication standards, your device is talking to the internet and it's or something like that, I would really think at that level, given the amount of art that's there, you're probably better off in a defensive patent pool. If it's something much more specific, Bill was talking about particular kinds of engine control mechanisms. If it's a particular spark advance algorithm or something like that, then I think it's a much more narrow field, and you can probably think about building out the portfolio yourself, or maybe yourself and some of the friendly car manufacturers that you have of other supply relationships and partnerships with. You could also form a intellectual property cooperation agreement with them. So I'm afraid, and I hate to give answers like, well, it depends, but in this case, it really kind of comes down to that. And there are law firms out there that are really starting to specialize in this area. Certainly in the digital area, there's a couple of really solid people out here that they can give pretty good advice. The other thing that I would say is that there are pools of people like IRI, where it's basically industry groups where people get together and specifically talk about what's the best intellectual property strategy for a particular application, and going to participating in those and getting invited to those is a good way to keep abreast of what might be the best business guidance as opposed to what the best legal guidance is.
Thanks. So suppose you're in a product company and but you have you have a new AI application that leverages data from your physical product, or you're thinking of, and you file a patent on that, maybe get it granted. Is your advice to really spend time trying to find everything related to that area that you can and patent it, even if you might have been disinclined to do so in the past? So patent surrounding, create a thicket essentially around your digital intellectual property. Is that what you're recommending to do?
Yeah, when I say a thicket, though, it's different than I think of the traditional areas. Is you want to really have good, solid, what I call litigation quality patents that are capable of getting an injunction. Because if they're not, they're not worth much. On the digital side, it's a matter of, and this is my word choice, I viewed patents more as inventor recognition. When you talk about building out a thicket, you sit there and people have a new idea. And basically, if the patent attorney felt it would be patentable, we'd go ahead and file the patent. What we didn't do was spend a lot of money on prosecution. We would sit there and we would file the patent. And when the patent office would come back and say, well, we're not going to allow this claim. We'll only allow this claim, and this claim. You'd sit there and say, okay. And you'd take what you get. And in other words, you don't drive the costs of getting a patent up. You keep the costs of getting patents down into the low thousands of dollars. You don't let them run up into the 20 and 40,000 that you need for a good pharmaceutical patent. So I really think that that when we talk about, yes, you build it out, think of it as a quality kind of a thing, because a patent thicket in a traditional area is really expensive but really hard to break through. A patent thicket in a digital area is really it's about puffery. It's about convincing people to behave honorably, to cross license with you, to not go to court, and if you got to court, to just kind of have a reasonable settlement. You want numbers in both cases, but it's different quantity and certainly a different price point to obtain.
So from the perspective of, you're leading an R&D function, and you have that, you've started to, add digital features and intelligence and so forth, and algorithmic interpretations and so forth to your product. Do you, but your history is, like you said, you patent very selectively. Would you recommend that people really, get the group together, build out and prioritize and start patenting much more prolifically in the digital areas?
Yeah, I would, but there have been some people who've recommend that you do that strategy. In other words, you have a brainstorm session, you collect the ideas, and you patent everything that you came up with. Because reduction to practice is often pretty easy to get by the patent office in that case. But you have to focus. The people that you're asking to do that are your product developers. So I tend to think that the better strategy is you have your product development team go do the work, the business assignment that they have. We need a particular kind of thing, and you don't build the patent portfolio out purely for its own sake, for negotiation as a defensive strategy. That costs you too much money, and it uses up a precious resource for defense. So I'm a person that believes that the best defense is a good offense. I'd rather have my team creating new advantaged product features in the market that's going to attract customers, rather than having them build out a defensive portfolio from what I already have. Because in the digital space, again, the churn is much faster. The features keep upgrading. I think it's better to offensively run faster. But as I say, when somebody comes up with something and it looks like it's unique, give it to the patent attorney or agent, have them file like I say, what I call an inventor recognition patent. It's whatever you can get from the patent office easy, and the person feels good for the recognition, and it adds to your portfolio when the time comes.
Yeah, and it may be something that's really significant, so you don't want to just blow by that, I guess. But
I'm being a little bit flippant in my answers here. To your point, I think any reasonable person is going to sit there and look at, well, is this a really breakthrough piece of work? Is it really something that's going to end up being distinct? And if it is, then I think the company, especially in the digital space, has to ask itself the one question that was asked earlier: well, do I really want to patent it at all? Is this better held as a trade secret? I mean, so I don't mean to be flippant about, well, they're just, you don't put any thought into it, but you do want to pay attention to what, when you think you have something good, you sure want to take advantage of it on both sides of that fence.
Yeah, I'm going to encourage people to put questions or raise their hands. I'm not sure I'm going to be able to see the raised hands, but if you can do that, Sabrina will see them. Raise your hand or put your question in. Paul, if I'm summarizing from a pragmatic perspective, it's sort of two things. One is lower the threshold for patenting something in your mind. Previously it would have been, and the second is having a different kind of patent attorney who's used to operating in that kind of space.
Yeah,
is that fair? Or?
That's fair. I think if you went to an artist, it's sort of like, if I had a traditional one, when I say litigation quality, I'd probably ask Rembrandt to do my painting on if I had a really good traditional product that was really unique. If it was on the software side of things, and I had a lot of art in the field, I'd ask the guy down the street to go ahead and file the patent. Yeah, I mean, and again, I'm giving general advice here, and I hope people
Yeah.
are wise enough to know to take it as a posture as opposed to a rule.
Right, you're helping us rethink maybe some of our assumptions.
Yeah.
Here's a question from Anand. How does the classification system, maybe he says it's maybe basic, the US patent classification system and the international one differ, and does that have implications for the way you do this?
So the answer is the classification systems do differ, but how do I want to say this? And so yes, you could sit there and create a concordance for which are traditional and which are digital on the basis of US or international classifications. I don't know of anybody that's actually done that. I think it's easier to put on a business hat as to which side of the fence it's on. And I wouldn't say that I've seen, I don't know of any, like I say, I don't know of anybody who's actually looked at the data that's been litigated and done it by either classification scheme and then looked at which strategy by classification scheme. Might be an interesting project. I don't know of anybody that's done it.
Chris Lewis has a question. Does your comment that courts are permitting offending companies to stay in business apply to all patents in the digital space, or just what are called standard or essential patents, standard essential patents?
No, I would say when they stay in business, it's usually in the digital space. It's usually they do not offer an injunction. They offer damages and a royalty penalty.
And that's the end result. They don't just do that while the case is pending.
Oh, well, yeah. It's no. That's the end result. Yes, it's very hard to get an injunction prior to a decision.
And
thanks, Paul. Thank you.
Mm-hmm.
Thanks, Chris. Any follow-up?
Yeah, I will definitely humbly say, Paul, I definitely support the proposition as a chemical patent attorney, but I also haven't met anyone who is expert on both sides of that chemical and software space. So it's amazing how out of our league we can get in our special world of patent law and the further subspecialty. So it's a question just out of curiosity and how different you found the digital space with the rest of the patent world. When I looked at your paper and heard your talk, one of the propositions is that force of a patent, that injunction force is so important to many chemical and other companies.
Yeah.
And when you don't have it, when you're stuck with having a court imposed fair and reasonable royalty rate, or just not getting that injunction, you're just really different. The playing field's much different, as I think the whole crew recognizes. So I just wanted to explore what the limits are. I don't know whether it's even possible to get an injunction in the digital space. When you look at the case law, they don't really go out of their way to bucket it, if you will, to put it in separate categories. But I hear you. So it's a really important point.
Well, I'll tell you, it hit me across the face with a 2x4 because I was brought up in a traditional environment, as we're describing them here. I always thought of that I had, the ability to get an injunction, and I worked really hard to make sure I was honorable. And when somebody infringed me, I was able to get injunctions against them. And when I went into the software space and started associating with people that were exclusively in the software space here and looking at what they were doing and what they were facing, it was just sort of like, well, wait a second, you just have them stop making it's simple. And the answer is, No, it's not. And what I think really happened, and again, this is conjecture, personal on my part. I think what happened is the court saw that the art was so overrun. If you look at Apple and Samsung, again, just as an easy to understand example, I don't want to pick on it, but you had all this patent, you had all these millions of cell phones all over the world. And I think the judges said, wait a second, I can't give an injunction that says that one company can't produce the phone because of this or this, and we can't make all the consumers give it back. And you know, I think they just decided we need a more practical solution to this. And like I say, I've got my own personal feelings about what was right, wrong, ethical about it. But that's why I said with that, it's the environment slide. Like it or not, that's the environment. Our challenge, I look at my challenge as an R&D leader. How do you operate in that environment? And this is the best guidance that I know of right now, and it could change over time.
Well,
Thanks, Paul.
Does this strategy tend to favor larger companies with large portfolios or upstarts that can't be blocked? As has the balance of power changed between startups and large companies or not?
Well, the answer is I think it has, but if I go back to even traditional companies, the patent system has always favored those with deep pockets to bring lawsuits, and it is really hard if you're a small company to convince any kind of an investor team investment group to go ahead with a lawsuit. Usually the best thing at that point in time is you, in worst case, you take your lumps and you give your intellectual property to some litigating firm on contingency and see what the investors can get out of it. But life has always been tough for a small company in my experience. That's life. I mean, again, it's one of those environmental things, I think, and it isn't just intellectual property. It's tough for a small company. Lots of things are distribution channels, you name it.
We've got another question from Anand about tech platform strategy, patenting strategy. Can companies patent part of their new tech, an anchor patent, and keep building trade secrets on it, or vice versa? Sort of, where do you draw the line, I think, between patenting and trade secrets when you're working in when you're trying to develop a tech platform? Is that a good summary? Not Paul, go ahead and answer my best.
So the answer is that when we get into trade secrets, a month ago, if we'd had this thing, I would have told you that the trade secrets were definitely a good way to go. And then now in this last month, the courts are starting to really change in terms of what's allowable for a trade secret, and it's what I'd say right now is that trade secrets have all of a sudden gotten really uncertain in my mind in terms of enforceability. I still think that if you really have a way to keep your trade secret secret, in other words, it's you're not relying on the court to keep it secret, but you have the good internal controls to keep it secret, then in a lot of cases, that's a really good strategy. I'll give you and it depends upon the industry. I'll give you the classic example, and one that I'm personally familiar with. One of the companies I worked with was James River. It was a large paper company. We would sit there and we would design the what's called the head box, which determines really it's how the paper is going to end up performing when it's all finished. It aligns the fibers in a very particular way. And the way in which a head box designed to take a slurry of pulp and put it out onto a sheet with the right orientation is really an engineering feat. And we would literally design those head box. You'd have them manufactured. You'd weld them shut. You'd basically execute the designer that designed it. You'd burn all the paperwork, and no one would ever open the box. Now I'm being facetious here, obviously, but that was a trade secret, and it was secret. It just there was no way to, unless somebody went in there with a welding torch, and these were big metal boxes, there was no way you'd know what was inside of it. So when you have physical products that have that kind of attribute, you're much better off with a trade secret than you are a patent. When I was with James River, they were almost all trade secrets and no patents. The previous company, Raychem, there was the inverse. The same thing's true on the digital side. If you think the code is written in a way, and the way in which you're storing it on your servers and the security is such that it's the equivalent of my sealed metal box example, well, then I think that's a good way to go. If it's stuff that's gonna be able to be out and about and downloaded on people's phones, and it's residing on the phone, then I think that you're better off with a patent. I don't know if that's helpful, but that would be some thoughts.
Paul, thank you for your time. I think we're out of time, and thank you for all those who joined us today. It was very interesting and stimulating discussion. So thank you very much to everybody, and we'll see you at the next one of these lunch and learns, which should be in first Friday in June, I believe.
Yeah. Thank you, everyone.